You got hurt at work today. Your right to choose your own doctor in a workers' comp claim in Illinois is about to be tested, and you don't know it yet. Your supervisor hands you a card for the company's occupational health clinic. The doctor documents your injury, releases you to modified duty in 2 weeks, and the claim moves forward on his report. Most workers never learned that was a legal mistake. That doctor is paid by the same insurance company now evaluating your claim. And under Illinois, specifically 8020 ILCS 305, Section 8A, you had the right to choose your own treating physician from day one. The company can recommend their clinic. They cannot legally require it as your primary provider. You had first choice. If that's the law, why do so many workers end up at the company clinic anyway? And what does it actually cost them? That's what this video answers. What Illinois actually says. The section of the Illinois Workers' Compensation Act that governs physician choice is 8020 ILCS 305/8A. Understanding your rights under that section requires knowing which situation you're in because the rules differ depending on whether your employer has an approved panel of physicians. If your employer does not have a panel of physicians agreement, Illinois law gives you the right to choose your own treating physicians from the outset. You make the first choice. The employer pays for treatment within your chosen physician's care and their referral chain. If you become dissatisfied with that physician, you can switch to a different provider. The employer pays for that treatment as well. If your employer has a panel of physicians which require an agreement with employees or their union representative and approval from the Illinois Workers' Compensation Commission, your first choice of treating physician comes from that panel. You have the right to switch to a different physician within the panel if you're not satisfied with the first. Outside the panel, employer-paid treatment gets more complicated. Here is what both tracks have in common. The company clinic your supervisor handed you a card for is not automatically required primary treating provider. If there's no approved panel in place, you had free choice from day one. If there's a panel, the clinic needs to actually be on it for the employer's direction to carry legal weight. Either way, the supervisor saying you have to go there is not the same as Illinois law requiring it. Most workers don't know which situation they're in, and companies count on that. Now, emergency treatment is a different matter. If the situation requires immediate care, you take what's available. But for non-emergency evaluation and follow-up treatment, your right to choose your treating physician is primary under Illinois law. What the company doctor is actually doing, the occupational health clinic your employer sends you to has a relationship with the employer's workers' comp insurance carrier. In many cases, that clinic's business depends on referrals from that carrier and from the employers it insures. That relationship creates an incentive structure that's not aligned with your interests as an injured worker. Company doctors in workers' comp cases are statistically more likely to minimize injury severity, release workers to duty sooner than the medical picture warrants, and conclude that your symptoms are pre-existing or unrelated to the work incident. I've seen the reports. I've challenged those reports in arbitration. I've deposed doctors who wrote them. The pattern is consistent and it's non-coincidental. The reports coming out of employer-designated clinics consistently underserve injured workers. This doesn't mean every company doctor is acting in bad faith. It means the system they operate in points their incentives in the wrong direction. How this connects to the IME? The dynamic I'm describing here is closely related to something else you may encounter, the independent medical examination, or IME. The IME is a separate medical evaluation ordered by the insurance company during your claim, and the doctor performing it is also chosen and paid for by the insurance company. We have a full video on this channel covering how the IME process works and what to do before you walk into that room, because it deserves its own careful treatment. But the connection to physician choice is direct. When the insurance company influences both the IME doctor And to the extent workers allow it, your primary treating provider, they're building a medical record that supports their position in the claim, not yours. The physician you choose is the single most important factor in how your injury gets documented on paper. That documentation follows the claim everywhere it goes. If you're dealing with a delivery driver coverage dispute and also facing pressure to use a company clinic, those two issues are connected. The contractor misclassification question and the physician choice question often come up in the same case. We covered the coverage side of that in our video on delivery driver workers' comp rights in Illinois. And the same physician choice rules apply once coverage is established. When a second opinion matters most, if you went to the company's clinic and you're not satisfied with the care or the assessment, you have not necessarily lost your right to independent care. You may still be able to switch your own treating physician under your second choice right, depending on where you are in the claim. The timing matters and the execution matters. A second opinion is most critical in these situations. When the company doctor is clearing you to return to work and your injury doesn't feel resolved. When they're finding no objective basis for symptoms you're clearly experiencing. When they're attributing your injury to a pre-existing condition you've never had issues with before. Or when the gap between what the doctor reports and what you experience in your body is wide enough that it's affecting your ability to function at work every day. Here's something I tell every client who calls after several weeks of treatment with the company's provider. Going to the company clinic early on does not automatically close the window on independent care. We look at what treatment you received, what the records show, and whether your second choice right is still available. In most situations, it is. But the sooner you redirect your care to a physician you've chosen, the more of your medical record reflects your independent count of the injury. And that difference can be significant when the case gets evaluated. An independent physician who examines you and documents a different clinical picture changes the trajectory of your claim. It gives an arbitrator at the Illinois Workers' Compensation Commission a conflicting medical record to evaluate. In workers' comp cases, a well-documented conflict between the company's doctor, what the company's doctor found, and what an independent physician found often resolves in the worker's favor when the independent physician is credible and your injury history is consistent. What to do when the employer is blocking independent care. This happens. A worker tells the employer they want to see their own doctor. The employer insists the designated clinic is required. Benefits are threatened if the worker doesn't comply. I've had clients come to me after months in the company clinic because they genuinely believed going elsewhere would cut off their checks. Here's what to document if you're facing this. Keep any written communications from HR or your supervisor directing you to a specific clinic. If the instructions came verbally, send a follow-up email confirming what you were told. Something like, as we discussed, you've directed me to use the clinic at this address. Please confirm. That creates a written record of the direction you received. If the employer is conditioning your benefit payments on your use of their chosen provider, that is the moment to have an attorney involved. The employer cannot legally tie your workers' comp benefits to your agreement to see their doctor. If they're doing that, they are operating outside the bounds of what Illinois allows, and the remedy exists. The question to ask yourself right now is simple. Are you receiving treatment from a doctor you chose or from a doctor your employer pointed you toward? If the answer is the second one, and especially if the doctor's assessment doesn't match what you're experiencing, you have options. Call an attorney before you make any decisions about switching providers or accepting the company's medical conclusions as final. If this connects to where you are in your claim, watch my video on the IME next. It covers what that exam is, who the doctor actually works for, and what to do before you walk into the room. The IME and your treating physician are more connected than most workers realize. If you have specific questions about your situation, contact information is in the description. Drop your question in the comments too, and I'll respond.